Now let us go to a topic of how accountability is ensured in higher judiciary. So why this topic? ये वाला I think I'm repeating it for the third time. A bench of 5 senior most judges of Supreme Court expressed serious concern about comments made by Karnataka High Court Justice V. Srishanand in September 2024. During a hearing, Justice Srishanand had referred to a particular locality in Bangalore as being in Pakistan. In another hearing, he had made an objectionable comment against a female lawyer. So these things were taken by Supreme Court and they had expressed serious concern. But in judge ने कहीं पे माफी वगैरह मांग ली थी, तो the matter was not taken ahead. But the point is, through this, several articles came about how to hold judge accountable, how to hold judges of higher judiciary accountable, what are the current mechanisms and what improvements are needed there. समझ में आ रहा है न्यूज में क्यों था? There were several articles about improving the situation. We will talk about how to improve the situation. How accountability is ensured in judiciary. How accountability is ensured in judiciary. तो देखो, one is remove judges, है ना? सुप्रीम कोर्ट से जज को हटा दो, हाई कोर्ट से जज को हटा दो. देखो, one thing is when judges have उनका misbehavior has been proved, or it has been proved that they are not, they do not have the capacity to remain a judge, they can be removed altogether. The process for it has been given in the constitution itself, and some of the responsibility was given to parliament. The parliament has made a law for it. So what is the process? देखो, under article 124 clause 4, it has been said that a judge of the Supreme Court shall not be removed from his office except. So when can a judge of Supreme Court be removed? Judge of the Supreme Court can be removed by an order of the president passed after an address by each house of the parliament supported by a majority of total membership of that house and by majority of not less than 2/3 of the members of the house. So basically, a judge of the Supreme Court or Supreme Court can be removed by president after an order has been passed or after resolution has been passed in both houses of the parliament by special majority. Special majority, 2/3 of the members present and voting, and at least majority of the total membership of the house. Article 124 clause 5 says that ये जो process है, it can be regulated by a law of parliament. कि how would the in what cases this procedure will start, how will investigation happen, when would parliament's role of voting come into play. All those things can be regulated by a law of parliament, and parliament has passed Judges Inquiry Act 1968 to explain the to give more details about the procedure. But for removing the judges of High Court, under Article 217 clause 1 subclause C, they have said that the same procedure as given in Article 124 clause 4 would be followed. So जैसे judge of Supreme Court would be removed, in the same way judges of the High Court would be removed. Okay, but as per Article 124 clause 5, Parliament may by law regulate the process. ये पूरा process will be regulated by Parliament. So Parliament has passed this law where they say that this is the process that has to be followed. First, if a removal motion has to be introduced, it will be introduced either in Lok Sabha or Rajya Sabha. In Lok Sabha, at least 100 members should be supporting it, and Rajya Sabha at least 50 members should be supporting it for that motion to be introduced. If only one MP comes and says a motion for impeachment procedure of a judge of the Supreme Court or judge of the High Court, it will not even be initiated. Substantial number, 100 in Lok Sabha and 50 in Rajya Sabha at least, if it is introduced. Then Speaker or Chairperson may admit the motion or refuse to admit it. If it is admitted, then investigation by a 3-member committee takes place. This 3-member committee will consist of the Supreme Court judge, a Chief Justice of High Court, and a distinguished jurist. This 3-member committee will give its report. if the committee finds the judges guilty of misbehavior or suffering from incapacity. दो ही grounds है जिस पे judge can be removed. Judge is guilty of misbehavior or judge does not have the capacity. So, suffering from incapacity, the house takes up the motion for consideration. Then the house will take up the motion. Before that, house will not vote on it. Motion was introduced, chairman or speaker accepted it, and what happened? Committee was created. Then committee's report would come. If in the report the judge is guilty, judge does not have the capacity, or judge is suffering from incapacity, or judge is proved guilty of misbehavior, in that case both the houses have to pass the motion by special majority, and only then the president can remove. If the motion is passed in both houses, the address is presented to the president, then the president passes an order for removing the judge. This is the process of removing a judge. On how many occasions have this mechanism for removal of judge of the higher judiciary been used? So it has been used, or the removal process has been triggered 5 times. By triggering 5 times means introduction in Lok Sabha or Rajya Sabha. 5 times for entire Supreme Court and High Court, all the High Courts together. It has been triggered 5 times. It has never been passed in both houses of the parliament. एक house में pass हो जाता है, and if there is a scope for it getting passed in the second house, judge himself resigns rather than getting impeached. So it has been triggered 5 times against Justice V. Ramaswamy in 1993, Justice Soumitra Sen in 2011, Justice J.B. Pardiwala in 2015, Justice C.V. Nagarjun in 2017, and Chief Justice Deepak Mishra in 2018. The proceedings has, however, never been successful, though Justice Sen was impeached by Rajya Sabha. Justice Soumitra Sen ke removal ka motion was passed by Rajya Sabha, and subsequently he subsequently resigned ahead of the impeachment motion passed in Lok Sabha. In case of Justice V. Ramaswamy, the motion was defeated in Lok Sabha. In 1993, it was introduced against V. Ramaswamy. It was defeated in Lok Sabha only. So the highest that we have gone, the furthest that we have gone, is in the case of Justice Sen, when it was passed in one house, but before it could pass in the other house, before the motion could be passed in other house, Justice Sen himself resigned. तो वो impeachment process का जरूरत ही नहीं पड़ा. Okay, now in-house peer review procedure for correcting deviant behavior which does not warrant removal but only imposition of minor measures. अब देखो, removal is what? Proved misbehavior पे removal हो सकता है, but misbehavior has different scales. One misbehavior is making a comment on a lawyer, which may be indecent. One misbehavior is involved in corrupt activity. Now, this comment may be subjective. Some may consider it indecent, some may consider it मजाक था. And यहाँ पे thus removal perhaps is a very strict measure. Some people may say कि नहीं, यहाँ पे भी removal होना चाहिए. But it may be very strict, and thus removal में you may not get the right kind of support in the parliament. Corruption proved है तो removal पक्का होना चाहिए. But for other behaviors which may not need removal but some punishment, there is an in-house peer review procedure. What happens in this process? So this procedure was declared by a resolution of full court in 1999. Supreme Court in 1999 had created this procedure. This is the in-house procedure. Here, the logic for in-house mechanism was simple. Impeachment process was very cumbersome and required intervention and willpower to succeed, or willpower की ज़्यादा होना चाहिए, political will to succeed. So impeachment is a very cumbersome process, and impeachment may not be needed every time. So in this process, what happens when a complaint is made against a judge? Complaint is made to the Chief Justice of the Court, Chief Justice of India, Chief Justice of the High Court. The Chief Justice of that court determines whether it is serious or not. If it is serious, then Chief Justice of India will take it for further action. Here, a 3-member committee of either High Court or Supreme Court judges examine the complaint. If the complaint is serious, then the committee may recommend initiation of removal process also. But if the complaint is not serious, then some other punishments may be given. Transfer ho jana, those kind of things may happen. But So this is the in-house procedure, in-house mechanism. What is in-house mechanism? A complaint may go to Chief Justice of the court. Chief Justice may accept it, form a committee. That committee may, after investigation, find that complaint is very serious. Then the committee may recommend this judge for removal, and the role of Parliament would come then. President and Parliament would come. But if it's not serious, then some वो क्या बोलते हैं, warning देके छोड़ दिया जा सकता है. Those kind of things may happen. Okay, so these are the two methods we have. One, complete removal process. One, in-house procedure to hold judges accountable. But this system suffers from various challenges. First is, tedious and lengthy process have resulted in no judge from higher judiciary getting removed under the mechanism yet. So far, no judge has been impeached. अब एक जज impeach हो भी जाते, but he resigned earlier. Both the houses, special majority in both houses is a very difficult thing to achieve. Second, the current mechanism of the removal depends on mercy of politicians, and thus, in cases of judiciary politics nexus, removal of a judge in higher judiciary may be impossible. Suppose a judge is found to be involved in corrupt activity, but वो corruption कर रहा है government के साथ मिलके, government which is in power. In that case, taking action against this judge may not ever be possible because government has majority in Lok Sabha. If it has majority in Lok Sabha, majority में 2/3 special majority for removal of this judge may be difficult. Judges continue in their post during the removal process. That's also a very important issue. देखो, judges का investigation हो रहा है. Three judge committees investigating that. In that scenario, or 3 judge committees doing detailed study on the case, even then that person remains judge of Supreme Court or judge of High Court and keeps on taking important decisions. The 1968 law does not say that in cases of such investigation, the judge should be suspended or judge should be not not playing his role in judiciary. Then, lack of transparency in the inquiry process, both at in-house process level and in the inquiry committee at the level of Parliament. What is this issue of lack of transparency? देखो, in-house process में, जैसे Justice AP Shah claims that most of the time the forwarded complaint are not even acknowledged. Complaint should go to Chief Justice of the court. It's not even acknowledged. No inquiry takes place in most of the cases. No one knows how many complaints were received by this in-house mechanism, how many were entertained, and so on. No, there is complete lack of transparency. If you ask कि दिल्ली में हाई कोर्ट है, उस हाई कोर्ट में in-house complaint mechanism में कितने जजेस के अगेंस्ट कितने complaints आए हैं, you will not have that data. So there is complete lack of transparency. In-house process also lacks statutory or constitutional backing. It was created in 1993 through a resolution of Judiciary, but it doesn't have any statutory or legal backing. So what do we need to do to improve the accountability of judges? We need to bring a statutory mechanism. In 2010, such a bill was introduced, just Judicial Standard and Accountability Bill was introduced in the Parliament, but it could never get passed. It was passed in Lok Sabha, but it eventually lapsed in Rajya Sabha. It eventually lapsed with dissolution of 15th Lok Sabha. It was never passed in Rajya Sabha. So this kind of bill, which will lay down enforceable standards of conduct for judges, which will provide that judges should declare their property and assets of their family members also. It should provide for a better institutional framework. The current institutional framework is cumbersome, lacks transparency. The bill, Judicial Standard Accountability Bill, if this kind of law is brought in future, it should provide for better institutional mechanisms. A new and more detailed code of conduct guiding judicial behavior is needed. Ensure that only high quality judges are appointed at the first place, so that chances of this kind of problem occurring on the upper area would be on the other side would be difficult. Supreme Court should clarify the extent and scope of RTI applicability also. Extent and scope of RTI applicability, like there are different judgments by various high courts where sometimes certain things are made available to public, sometimes other things are not made available to public. ये RTI के अंदर आता है, ये RTI के अंदर नहीं आता है. This kind of arguments are made. So once and for all, Supreme Court should clarify what are the things on which questions can be asked, what are the things on which questions cannot be asked. Then judiciary can also be brought under the scope of Lokpal. This has happened in countries like Sweden. Judiciary comes under the scope of ombudsman. If that is done, that will be another mechanism of holding judiciary accountable. Streamline process for regular performance evaluation of judges. This is another thing. There is no performance evaluation of judges. If you have become a judge, how well you are performing, there is no objective mechanism for that. तो आपका अपॉइंटमेंट ऊपर होता है, आपका प्रमोशन होता है, all that sometimes depend on how close you are to the people who are appointing rather than performance. So we also need to develop a performance evaluation mechanism for judges. So there are lots of things which are needed to ensure accountability of judiciary. It's very important because what is at stake is the trust that the courts must inspire in those who are brought before them in democratic society. A lack of trust is lethal for democracy and development and encourage the perpetuation of corruption. And for this trust to develop, कि नहीं judiciary काम अच्छे से ही करेगा. Judiciary should be working in a transparent manner, should be working in an accountable manner, and judges against whom complaints come, unka proper investigation and acquittal or conviction should take place. We get it? ये पूरा topic समझ में आया सबको? There are two things that we do. One is the constitutional method, other is the in-house process, but both the things are problematic as it's time consuming, cumbersome, it enhances judiciary executive nexus. We have seen no judge has been impeached so far. There is lack of transparency on how many judges, against how many judges have complaints actually come. All these issues are there. We should be focused on dealing with these issues.